Randy, long and short, the Attorney General called 5 prosecution witnesses. 5. At the end of the day, we indicated to the court that from what has transpired relative to all the prosecution witnesses, we believe that no case had been made against the Honorable Ato Forson. The trial judge, in her wisdom, said she believed that a prima facie case had been made and that we should open our defense. Immediately we mounted an appeal on the ruling on the submission of no case, which appeal was yesterday, decided upon. Now, Randy, what for me interests me in all of this is that in the ruling of the trial court, calling upon us to open our defense, we obliged. And so you notice from the records that we called 2 witnesses to testify on our behalf, upon which we close our case. Then the second accused, Dr. Animana Sylvester, also opened his defense. But along the side, he became very sick and so had to go outside the country for medical treatment. The Attorney General later indicated that out of compassion, he was filing a nolle prosequi. But later, I will tell you something. Now, when they filed a nolle prosequi, it was left with the Honorable Ato Forson and Richard Japa. And the rest of it is a matter of public record. So yesterday, the Court of Appeal, as you indicated, by the 2-1 majority, delivered its ruling. And Randy, I just want to read some portions of the judgment for our viewers. And those who have it, I'll refer them to go to pages 25 of the judgment. This is what the court said. I note that Mr. Markwe, he works at the Bank of Ghana, in particular said in his evidence, for whatever reason, that the first appellant instructed the Bank of Ghana to establish an LC in favor of Big C in the letter dated August 7, 20. Now, at the cross-examination of Markwe, we showed him the letter Ato Forson wrote, that he should read where Ato Forson instructed the Bank of Ghana. He then indicated on oath that it was an incorrect statement and that Ato Forson only requested. How in God's name can such a person be considered to be a credible witness? So the court, this is what the Court of Appeal, at the trial, when he was challenged on the use of the word instructed, and in my opinion, he chose to equivocate on it instead of accepting it. In my view, this was unnecessary posturing because the first appellant did not use the word instruct, but rather requested in the letter he wrote. So these are witnesses that were coached. And this Markwe guy works at the Bank of Ghana. He saw the letter Ato Forson wrote, never using the word instructed, but they wanted to create a certain narrative as though it was like, I authorize you to do something. And so they needed to insert the word instruct instead of the request. You do know that when I request you to do something, you have the benefit of looking around the circumstances and deciding not to. But that would defeat their case. So they introduced the word instruct as though it's an authority. It's a command. Knowing very well that was not. So the judge said, why in God's name would you do that? Now listen to what the judge said. Mr. Markwe told the court that the letter of 7th was on the letterhead of the Ministry of Finance and was signed on behalf of the minister. The letter was signed on behalf of the minister. So at this point, the minister on whose behalf the letter was signed is a material witness for you. They never called Setepe. And still managed to build a case that the Honorable Ato Forson acted without authority. Whose authority? Definitely his boss. So if you are alleging that there was a lack of authority, then you needed to call him to assert that he never authorized him. But Godfred knew that there's no way he could proceed with that assertion. So, see what the court said. Mr. Makwe also said that the LC is not payment, but a guarantee. Now listen to what transpired under cross-examination by my senior Dr. Bamba. So you agree with me from the explanation of the letters of credit that the letter of credit in itself is not payment, would you not? Answer, yes, my lady. But the letters of credit guarantee payment. Question, a letter of credit guarantees payment subject to certain conditions be met. Is that correct? Yes, my lady. Question, therefore, it follows that if the conditions under the letters of credit have not been met, then payment will not be made. Correct? He said, no, my lady. It is only when the conditions are met that payment will be made. Now, guess what? The people Bank of Ghana reached out to find out whether the conditions have been made were Ministry of Health officials. They gave the approval that they have inspected the shipment, the pre-shipment, the equipment, what we call it, the letters accompany the ambulances and others, and they are satisfied. They can go ahead and do the payment. Not Ato Forson. And upon all this, he was called upon to open his defense. Defense of what? Randy, defense of what? And so the court now reasons, my lords, the evidence also establishes that the witness told the court that the first appellant was not the applicant for the LCs, but the Ministry of Health was. Again, this is what transpired when Makwe was further cross-examined by Dr. Aziz Bamba. Quote, take a look at Exhibit A for A1. It has a column for applicant, does it not? Yes, my lady. The applicant herein refers to the entity applying for the letters of credit, is that not? Yes, my lady. On Exhibit 1 for A1, the applicant is stated as the Ministry of Health, is that not? Yes, my lady. Upon all this, the trial judge said, Ato Forson, come and open your defense. That you authorize the payment. Look, you see, Randy, no Ghanaian, I repeat, no Ghanaian should be made to go through what Ato Forson had gone through in the past almost 2 years. I say this with heavy heart. Because you see, when a prosecution looks like, you see, ours is to prosecute. It's not an inquisitorial system. It's adversarial. And he knows that. What it means is that at no point in time should an accused person be put in a situation as though he is guilty, but he must establish his innocence. And you see, Randy, these things that I've referenced were prosecution witnesses. Prosecution witnesses. So the court now said, the witness also told the court that the document for payment included issued LC and documents such as pre-shipment inspection certificate or label, an insurance certificate, certificate covering all risk. When the cross-examination continued, the following evidence was further elicited. Who signed Exhibit 1 for A1? Guess what? It was signed by the controller and accountant general and the deputy controller and accountant general. So you agree with me that A1 was not the applicant in Exhibit 1 for A1? Answer. I did not get the question clearly. So Dr. Bamba repeated. The question is that A1, the Honorable Ato Forson, is not the applicant indicated on Exhibit 1. Is that not so? No, my lady. The Honorable Ato Forson is not the applicant for A1. And meanwhile, The trial judge says, come and open your defense. Now, see what the court said about Kweku Ajiman Menu, the person who went and reported the case to EOCO. Mr. Kweku Ajiman Menu also testified about the letters of August and this by the first appellant to request for the LC. I note that he initially said that the LC was requested without the notice of the Ministry of Health. But when he was confronted later about it under cross-examination, he accepted that his initial position was wrong. Mr. Kweku Ajiman Menu also said the LC is not payment, but a guarantee. Again, the following is a snippet. You have also served as the chairman of the Public Accounts Committee of Parliament. Is that correct? That is correct. So you have quite a working understanding of how LCs operate. Is that correct? Yes, I do. Are you aware, are you not, that the LCs are not payment in themselves, but guarantee or promise of payment subject to certain conditions being met? Now, guess his answer. That is so. This is Kweku Ajiman Menu. So, on what basis was Godfred Dame now asserting that it was Ato Forson who authorized the payment? On what basis? And that is why when he said he is going to the Supreme Court, I said, why? Is the Supreme Court going to manufacture evidence for him? This is what your own witness under cross-examination said before the court.
Help me with something. So if the case against the Honorable Ato Forson was that as deputy minister,
yes,
he was not authorized to sign those letters or that letter that he signed, and therefore he signed that letter, and the letter reads on behalf of the minister. What was the proof that was adduced in court to establish that indeed he did not have the consent or authorization of the minister to sign that letter?
No evidence. Nobody.
But is that not the case against him?
Exactly. Exactly. So now you see, sometimes the judge rather said the burden is on Ato Forson.
How? That an allegation is made against you that you didn't have the authority to sign. You don't have the authority of a minister. So prove that you have the authority. Is that what you're saying happened?
Yes.
Okay.
And you say
this judgment, did it speak to that?
Yes, it resolved it.
Okay. What did it say?
The court said that under our current constitutional arrangement and the jurisprudence that we know, criminal jurisprudence, first of all, the state is mighty. And so the burden to prove all the essential elements of the offense lies with the prosecution and not the accused. And so that invitation was like asking the accused person to assist the prosecution in his own...
Against himself.
Against himself. And that particular invitation offends the rule against self-incrimination. This is how the Court of Appeal resolved the matter.
But who made that assertion? Who accepted?
No, so I'm coming. Let me just read something to you. How the Court of Appeal went. It said further, by saying that Exhibit 54A1 had not been subject to cross-examination, and this Exhibit 54A1 was a statement Setekwe volunteered to Yoko that the Ministry of Finance asked for the LC to be established. That day, Dr. Bassett didn't come. So I cross-examined the investigator. So I showed him Setekwe's statement to Yoko. I said, who took this statement? He said, he did. Can you confirm the signature? He said, yes. So I said, okay, I will tender it to him. So I did. Then I asked him to read the entire statement. When the entire statement was read, the Honorable Setekwe indicated that the Ministry of Finance asked for the LC to be upon the advice by the then Attorney General. Right? So see how the High Court went about it. It says, my lords, in the first paragraph of my opinion, I refer to the quote that an accused person has the right not to be forced into assisting in his or her own prosecution. In my opinion, that protection afforded to accused person is anchored in the overarching principle against self-incrimination, which is firmly rooted in our constitutional law as a fundamental principle of justice under Article 19(2)(c) and the common law. The root of this principle is based on the presumption of innocence and the fact that the state, as the Hobbesian Leviathan, which prosecutes an accused, has more resources than the accused. In other words, until the prosecution establishes that there is a case to meet, an accused person should not be compelled to testify. It proceeds. As counsel for first appellant correctly observed in his submission, in the case at the bar, the law under which the first accused is charged does not impose a burden on him to explain whether he had an authority to act. He continued, he was not charged with a strict liability offense, but with willfully causing financial loss and misapplication of state property. It is therefore difficult to reason with the trial judge on her decision that the first appellant must testify to explain whether he had authority to act. He continued, further, by saying that Exhibit 54A1 had not been subject to the cross-examination. So after I introduced this Exhibit 54A1, the judge in her ruling then said, Setekwe has not been subjected to cross-examination. And so for that matter, she will not regard the statement the man volunteered to Yoku. That was tendered without objection. Shockingly. Now, so this is what the court said. So further, by saying that Exhibit 54A1 had not been subject to cross-examination, and that the first appellant should rather establish that he had authority to act, the learned trial judge, by implication, is saying that she had heard the prosecution witness, but she must also hear from the first accused in order to decide. I am of the view that that is tantamount to shifting the burden on the first accused to prove his innocence. It also implies that the first appellant will be found guilty if he fails to explain that he had authority to act. Randy. So, there's another portion that I just want to read. My lords, it is true that at the close of the prosecution's case, the guilt of the accused person is not supposed to be proved beyond reasonable doubt for the purpose of submission of no case. But the law requires that the prosecution must provide sufficient evidence, as per Section 11 of the Evidence Act, said that the evidence should be capable of convicting the accused if he or she does not offer any explanation. If there is no evidence to support the charge laid against the accused, the court must hold that no prima facie case has been made out and that the accused is entitled to be acquitted and discharged. Like you rightly pointed out, Godfred Dame called 5 prosecution witnesses. At no material time did any one of them say. What they rather sought to do is that Setekwe didn't say, but said the ministry authorized the establishment, requested for the establishment of the LC. If the ministry did, and you do know that the Honorable Ato Forson was the deputy, in God's name, why would you say that Setekwe didn't do otherwise? Setekwe is a living being. He's alive. He's here. If you believe in your story, and it is his authority that you are denying, what do? Call him to come and assert that I never authorized. Then Ato Forson will now have the responsibility of showing whose authority he acted with. Now, you see, something curious happened. The letter of 7th August that the Honorable Ato Forson wrote, requesting the LC, he copied Setekpe. So,
and did he sign on behalf of him?
Yes. Okay. So when the investigator came, I asked him, in fact, we quite my menu first, that this letter, is it possible for a deputy, you were once even a deputy minister, is it possible for a letter to be written on behalf of your board? He said it's a normal thing. So then a question was put to him. When the letter is written on behalf of your boss and he did not sanction it, would you not be subject to query? He said that should be possible. From 2014, when Ato Forson wrote that letter, to the time you are testifying, has there been any record of an inquiry against him? He said, not as he knows of. Upon all these matters, Ato Forson was still asked to open his defense. Randy. Now, you see what the judge said. My lords, as stated earlier, there is no link between the evidence heard and the element of the charge for the court to hold that a prima facie case had been made. Consequently, based on the evaluation of the evidence led before the trial court and the submission made on behalf of the first appellant, I am of the view that the prosecution failed to provide sufficient evidence that meets the threshold of connecting the first appellant with the offenses he's charged with and relates to the ultimate of proof beyond reasonable doubt. This explains why I take the position that the trial judge erred in her application of the law in calling upon the first appellant to open his defense. Curiously, I want to read this other portion. You know, Godfred had been talking about lack of parliamentary approval and what have you. I have never seen in my life a dishonest attorney general like Godfred. You called 5 witnesses to come and build up your case. Now listen to what the court said. First and foremost, I have no hesitation in dismissing the prosecution contention that the request for the LC was reckless and criminal because it did not receive parliamentary approval. The idea of parliamentary approval was never part of the prosecution's case, as it never found part of the particulars set out of the offense for which the first appellant was charged. With respect, it was an afterthought.
Really?
Yes. I will not place any weight on it. Regarding the court's position on the ZAT exhibit, with the greatest respect and deference to the trial court, that is not the position of the law. The document has some probative value for which some weight can be placed on it, or it does not. It is not the law that a statement ought to be subjected to cross-examination before value can be ascribed to it. So, you see, so Randy, if you pick all the things that transpired, and I want to also read this, it's very important I read. A reasonably drawn inference requires evidential foundation, which in this case is lacking, because no evidence was led to show that the first appellant had no authority to act. The fact relied on by learned counsel, with due deference to him, are based on conjecture and speculation. It proceeds. The issue whether the first appellant had authority to act or not is a matter of fact and cannot be speculated upon. Randy. There's a position that the court states so that at least you can take. It was stated that there can be no inference of guilt unless there are objective facts on which the inference can be made. If positive facts are lacking, as in this case, what is left is mere conjecture and speculation. In this case, by calling on the first appellant to open his defense suggests that he was only entitled to be acquitted if he proved his defense. That is show that he had authority to act to the satisfaction with respect, in my view. That was certainly wrong.